everybody. This one is called Fraud Upon the Court. We're going to go through some stuff that we've already gone through before, but it lays the foundation for fraud upon the court. When acting to enforce a statute and a subsequent amendment to the present date, the judge of municipal court is acting as administrative officer and not in a judicial capacity. Courts administering or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency. They're bought and paid for a clerk. It is the accepted rule, not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they are described as mere extensions of the administrative agency for superior reviewing purposes, as a bought and paid for clerk. Judges who become involved in enforcement of mere statutes, civil or criminal in nature or otherwise, act as mere clerks of the involved agency, okay? Statutes being the operative word, okay? Any judge dealing with a statute is a bought and paid for clerk. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. For a complete set of YouTube videos with private information shares, a DVD with over 50 searchable law dictionaries, and other books and forms, contact me privately at engineerwin@yahoo.com. And donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the IOUs, the military script, the Federal Reserve notes, the PayPal gifts, the checks, the money order. Send me an email for particulars. Oaths. All oaths must be lawful, allowed by common law or some statute. If they are administered by persons in a private capacity or not duly authorized, they're void. And this is taken from Book 3 of the Institutes and the Laws of England, and Book 4, which is Coke, going back to the 1500s. And that's a cite from Tomlin's Law Dictionary. The point being is that all government officials can be in their official capacity or their private capacity. And when they go outside of their responsibility or violate the law, then they immediately move into their private capacity. All government employees, judges, police officers, etc., can be in their private capacity or in their official capacity. If they do anything that's illegal or unconstitutional, they cease to represent the government. An officer who acts in violation of the Constitution ceases to represent the government. A clerk masquerading as a judge is not competent to do anything judicial like issue orders or warrants. A clerk masquerading as a judge is operating in his private capacity and has no immunity. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. If they spell your name in all block capital letters, they're operating in their private capacity. If they're attacking you with a statute, they're operating in their private capacity, okay, unless you're a government employee, okay? That's what statutes are for, is government employees. Statutes equals contract equals Roman cult. Did you give up your God-given rights for some satanic privileges? But individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association of which they're agents or officers, and they're bound by its obligations, okay? So what they're doing is they're assaulting you with their Cestui Que trust. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit at Sovereignty International. Don't forget to like this video on YouTube. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. This is the front page of my channel. The arrow is pointing at the bell. The subscribe button's already clicked because otherwise it's red. And the bell, when you click it, it looks like it's vibrating, but a pop-up will come up, and with a box you have to check saying you want to be notified about updates. Every taxpayer's Cestui Que trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. That's a summary from Henry Bolins in 1912. A summary from the Congressional Record of June 13, 1967, of 5 pages of the Congressional Record. is a citizen of the United States, is a civilly dead entity operating as a co-trustee and co-beneficiary of the Public Charitable Trust, the constructive Cestui Que Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And this is all coming from the Roman cult, folks. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holes, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks, and that's still to this day. The Roman cult runs the courts. To be bound in conscience to account to a Cestui Que use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's taken from, it's still the foundation of modern conveyancing. Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And this is the D.C. Code, which, nowadays it's called United States Code, but this is when it was actually passed, located at 31 Stat 1432, the legal estate to be the Cestui Que use. Okay, so again, it's all the Roman cult. The Roman cult owns and operates the District of Columbia, and the United States Code actually should be called the District of Columbia Code. This is, again, the D.C. Code at 31 Stat 1189, and right up at the very front it says, and be it further enacted that interpretation and construction of the said code, the following rules shall be observed, namely, the word person shall be held to apply to partnerships and corporations. This is an act to establish a code of law for the District of Columbia, which is really United States Code. Located at 31 Stat 1230 and Section 252, presumption of death. Okay, so they make the Cestui Que use, method of conveyance, and then they presume you're dead. Okay, so that's basically assaulting you with it everywhere. That's exactly what they're doing. Think about it. This is where it's codified. Statutes equals contract equals Roman cult. Did you give up your God-given rights for some satanic privileges? And this is Title 15, United States Code, Section 44, and the definitions. A corporation shall be deemed to include any company, trust, so-called Massachusetts trust or association, incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital or capital stock or certificates of interest. And then the second definition is the same as the first, except it doesn't have shares of capital or capital stock or certificates of interest. Read it. You'll see it. Vid.me shut down on the 15th of December, so all my YouTube videos there are gone. The YouTube channel called Sovereignty International is now free. YouTube didn't want any competition for their YouTube Red, I guess. And so they went and it was either going to be private or free. And so I, rather than make it private where nobody could watch the stuff, I made it free. Or I could have deleted it completely. But anyways, so I made all the exclusive content. All the exclusive content is still there, but it's only available through my website. I have 2 subscription levels, and I accept cryptocurrencies. The basic subscription level is $2.99 a month or $19.99 a year for the videos only. Then I have a platinum subscription level for $4.99 a month or $39.99 a year for videos plus unlimited consultations. Now, you have to understand the limitations on the consultations, because I'm not a liar. I meant an attorney. No, actually, I meant a liar. So what I can do is I can tell you what I would do for myself under a certain circumstance. And I can tell you where the forms are. But that's about the limit of what I can do for you. If you want me to prepare the forms, then you're going to have to pay me to do that. Okay, if you want me to review the forms, then I'm going to need a donation. That's the way it's going to have to work. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. I need other people fighting the battles, and I need them to be on point. I'm currently publishing a video a week. The important thing to understand is that if you want to use these subscriptions as a way of making a donation, then it's a modest donation. There's no doubt about it, but every little bit helps, and a whole bunch of people chipping in a lot adds up. So whatever is appreciated. Anyways, I'm currently publishing a video a week, and I don't expect that to change anytime soon. Arlington Private Information shares some of the exclusive content: land deed training, estoppel certificates training, foreclosure estoppel certificates training, corporate denial training, toll roads notice and demand training, invoice training, notice of void judgment training, revocation of signature training, third-party witness training, federal habeas corpus training, revocation of voter registration training, criminal complaint training. There's going to be more criminal complaint training. I just uploaded a video within the last week about some stuff to know as far as criminal complaints are concerned. I have also got gonna have some lawsuit training and other training. Everything that you need to free yourself is available for free on my free YouTube channel, Sovereign Living. All forms, files, and other instructions are available for free in my 2 private groups at Yahoo Groups and Google Groups. This training and these other things are above and beyond, and and you got to pay for that. But I've got everything that you need to free yourself is free on my YouTube channel and on my private groups. There's 2 national governments that exist. One to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And what the Supreme Court is essentially saying there, if you think about it, is that the D.C. Corporation is unconstitutional. And so that's the question is, do you know who you are? And you have to volunteer to participate. This is Chisholm versus Georgia in 1794. A state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. A state is altogether exempt from the jurisdiction of the courts of the United States or from any other exterior authority, unless in special instances where the general government has power derived from the Constitution itself. The question to be determined is whether this state, so respectable and whose claims soar so high, is amenable to the jurisdiction of the Supreme Court of the United States. This question, important in itself, will depend on others, more important still, and may perhaps be ultimately resolved into one no less radical than this: do the people of the United States form a nation? By that law, the several states and governments spread over our globe are considered as forming a society, not a nation. Now, the caps, notice nations capitalized, and those were in the original. The thing I want to point out here is at the time this case was decided in 1794, there was no nations on the planet. That's what they're saying here, okay, except maybe the United States of America. And so that's what they're saying here. A penal action, remember this is a statute, right? A penal action is an action on a penal statute, okay, an action for recovery of penalty given by statute. Well, think about it. A penal action on a statute is a bought and paid for clerk masquerading as a judge. Where an action is founded entirely upon a statute and the only object is to recover a penalty or forfeiture, such action is a penal action. The words penal and penalty in their strict and primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by a state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for noncompliance with an agreement. Okay, it's a contract. The words forfeit and penalty are substantially synonymous. A penal action is one founded entirely on statute and brought with the sole object of recovering a penalty or forfeiture imposed as punishment or specific offense, where all remedial action is one brought to obtain compensation or indemnity. Okay, so again, these are all based on statutes. It's all bought and paid for clerks masquerading as judges. A penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions, on the one hand closely related to criminal prosecutions, and on the other to actions for private injuries in which the party aggrieved may by statute recover punitive damages. Okay, again, statutes are only for government employees. Okay, that's all they're for. And once you understand that, then the judge is a bought and paid for clerk masquerading as a judge, another government employee. Okay. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile, Sovereign Living and Sovereignty International. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group, Sovereignty International, is being deleted. It takes time to ban 17,000 people off your group. My Yahoo private group is called Administrating Your Public Servants, and my Google private group is called Administrating Your Public Servants. Follow me on Twitter at EngineerWin. Follow me on vid.me at Sovereignty International. Actually, I need to delete that. Vid.me is history. It's not even there anymore, so I need to delete that. Follow me on Steemit at Sovereignty International. Uniform Commercial Code equals UNIDROIT equals Roman cult. Did you give up your God-given rights for some satanic privileges? Whenever this title, the Uniform Commercial Code, creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until the evidence is introduced that supports a finding of its non-existence. So what they do is presume that you're in a valid contract, okay, and then assault you with it, and then securitize it and sell it on Wall Street. And this is UCC 3-308, proof of signatures and status as holder in due course. In an action with respect to an instrument, the authenticity of an authority to make each signature on the instrument are admitted unless specifically denied in the pleadings. Well, and so they forge your signature onto a contract and then presume they're valid. That's exactly what they're doing. And then they sell it on Wall Street under 8.114 evidentiary rules concerning certificated securities. The following rules apply in an action on a certificated security against the issuer unless specifically denied in the pleadings. Each signature on a security certificate or in a necessary endorsement is admitted. If the effectiveness of a signature is put in issue, the burden of establishing effectiveness is on the party claiming under the signature, but the signatures are presumed to be genuine and authorized. Okay, so again, that's why you have to file a revocation of signatures. You got to dispute those signatures. He, the prisoner, has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights, except those which the law in its humanity affords him. He is, for the time being, a slave of the state. If a man be found stealing any of his brethren of the children of Israel, and maketh merchandise of him, or selleth him, then that thief shall die, and thou shalt put evil away from among you. That's why these Satanists want to get rid of their little common law problem, their natural law, because they'd be put to death for doing that stuff. And this is the real article, or the current Article 13 and Amendment, neither slavery nor involuntary servitude, except as a punishment for crime. Right. And so this authorizes slavery in America. That's what it does. It doesn't eliminate it. It authorizes it. It's exactly what it does. Everything they do is a fraud. A U.S. citizen's a fraud. Commercial papers a fraud. All mortgages are fraud. They get you to participate in their fraud, and then they assault you with one of their so-called contracts, and then they sell you into slavery. Everybody in prison was sold into slavery. Check out my other videos, Bankster Thieves Playlist, Roman Cult Playlist, Bankrupt Corporate So-Called Governments, Bar Members 1 through 3, Do-It-Yourself How Not to Volunteer for the Selective Service in the Draft, Martial Laws Here, Do-It-Yourself No Income Tax, Do-It-Yourself Free Mail, and Do-It-Yourself Kangaroo Courts 1 through 9, and the Canada Border Pigs Playlist, and Bar Members and their Satanic Connections Playlist. So, now we're going to get to fraud upon the court. Fraud upon the court is fraud which is directly directed to the judicial machinery itself and is not fraud between the parties or fraudulent documents, false statements, or perjury. It is where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function, where the impartial functions of the court have been directly corrupted. Okay, that's the 10th Circuit Court of Appeals. And so a fraud upon the court is when the judge is not neutral or unbiased. It's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. Well, when it's over a statute, he's not neutral, he's not unbiased, it's not a court. Okay? And so that's exactly what's going on, folks. It's fraud upon the court. And so when they say, what's your name or what's your birth date, what I would be saying is I neither admit nor deny anything. The burden of proof is on the prosecutor to prove his case. And then I might even say, are you trying to fabricate evidence of your U.S. citizen slave? Are you working for the prosecutor? Is this a court of law, or is there some fraud upon the court going on today? You know, and some nice, simple ways of doing it without being too confrontational. And what they should do is they should recuse, and you might want to bring it up, but this is actually, recusal is automatic. It's self-executing, okay? They should just automatically do it. It's because of the appearance of justice, okay? Any justice, judge, magistrate, judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned, okay? And so even if it might be questioned, he needs to recuse himself. He shall also disqualify himself in the following circumstances: where he has a personal bias or prejudice concerning a party, personal knowledge of a disputed evidentiary facts concerning the proceeding, when he knows, now this isn't all of them, quite frankly, there's more, but this was the ones that I figured I'd hit on. He knows that he individually or has a fiduciary or his spouse or minor child residing in the neighborhood has a financial interest in the subject matter in controversy. If they're getting a commission, then they got a financial interest. And they all get a royalty, okay? In the subject matter in controversy, or in a party to the proceeding, or any other interest that could be substantially affected by the outcome of the proceeding. Well, his royalty, he probably gets a royalty whether no matter what the outcome of the proceeding is, but still he gets a royalty. He or his spouse or a person within the third degree of relationship to either of them or the spouse of such is a party to the proceeding, is acting as a lawyer, is known by the judge to have an interest that could be substantially affected by the outcome, is the judge's knowledge likely to be a material witness in the proceeding. Okay, so anyways, 28 U.S.C. 455 is self-executing. Okay, they're supposed to recuse themselves if they know that this is going on. And so I wouldn't even, mention it, quite frankly. It depends. Depends on whether they drug me in there or whether I walked in there. Because I don't normally walk in there. They have to drag me in. Anyways, fraud upon the court is a violation of due process. It's a void judgment. Okay, watch the void judgments video. Okay, so that's what you call it, is fraud upon the court. And 28 U.S.C. section 455 is self-executing. And you might even say, well, maybe you should recuse yourself if you're not neutral and unbiased here. You're bought and paid for by him, then maybe you ought to think about letting somebody else take over this case. And when the judge has to get permission from the prosecutor, he's demonstrating, okay, when the judge says that there's no common law in here, he's demonstrating that it's not a court, that he's bought and paid for. Okay, you have to understand, you have to be able to read between the lines when they're talking to you in there, and you don't give evidence against yourself. If they start wanting evidence like a birth date and that kind of crap, then that's evidence that he's bought and paid for. Okay, and so and matter of fact, I don't even know that I'd give him a name. I'd tell him, well, I neither admit nor deny anything, and are you working for the judge? We got some fraud upon the court going on here. And so anyways, that's why it's called a kangaroo court. Okay, a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or other tribunal. And it's brutum fulmen, okay? It goes to void judgments, okay? Brutum fulmen is an empty noise, an empty threat, a judgment void upon a space which is in legal effect no judgment at all, by which no rights are divested, and from which none can be obtained, neither binds nor bars anyone. Okay, so are we doing some brutum fulmen here, some fraud on the court? So you just ask the questions. You know, they can't do anything for asking questions. Okay, and so you just ask the questions. Are we doing some void judgments here? Some brutum fulmen? Is there some fraud in the court going on here? Anyways, it's all called fraud on the court, fraud upon the court, and that's when the judge is not neutral or unbiased, and that means in a statute it's fraud upon the court. Anyways. That's it. This is a short one today. Thanks for watching. Have a great day.